if you're subpoenaed, what do you really have to give up, and how far reaching can it be? Talk about subpoenas, Brian. What's generally involved in the subpoena process? Like, how far reaching can it be if you're issued a subpoena?
Yeah, I mean, anything that's relevant is going to be within the scope of what they can ask for. You can really ask for quite a bit in the discovery process. We do requests for disclosure, requests for admission, and then ask for production. Now, and Lee can talk about this. We had another broker recently that was subpoenaed for production of documents, duces tectum, and it was about the scope of employment of one of their employees who was a party to a suit. And so, really, he can talk about the scope of what was provided in that, but they weren't even a party to the lawsuit, right? And so they were just being asked to, or really demanded to through the power of the court, to produce these things into this lawsuit. So,
yeah, and really, I guess the good thing to realize if you get a subpoena is that subpoenas are directed to third parties. So if you're getting subpoenaed, that means you haven't been sued,
right?
At least not yet.
Okay, all right, that's a good point.
Yeah, so subpoenas are typically directed to third parties, and there are limitations. I know, like in federal court, Rule 45 kind of breaks out what you can subpoena for and what the limitations are. There's a subpoena to attend a deposition. There's a subpoena to produce documents. Then you can issue a subpoena to appear in court, and they each have different limitations. There's a dispute right now where like you can subpoena a Rule 45 or a corporate deposition but you can't subpoena. So you can subpoena a company to give a deposition under Rule 45 federal rules. It's considerably less clear and whether you can subpoena a company to appear and testify in court, because you can only subpoena a person. There's case law to suggest that you can't. It's at least that I have seen, it's not been persuasive or has not been binding or overwhelming, compelling enough that you can still make an argument that you can subpoena them. But then you have limits, of course, on, I think there's 100-mile limit where you can have somebody come testify. You can have, you've got to be within the jurisdictional area of the court, which is part of the reason why I think there's an argument that you can subpoena a company to testify in the court, because what prevents a company, if you subpoena them, say, hey, and they designate a corporate representative that is across the country, and then that corporate representative shows up for the deposition, but they're outside of the jurisdictional limits when it comes to testify at trial, so that's a wrinkle with that subpoena. But typically, like for a trial, a hearing, a deposition, you can command them to appear within 100 miles of where the person resides. In fact, when I was in Louisiana, we had this issue in Texas. The third party that they wanted to subpoena was based in, I think, College Station. And, they issued a subpoena for Louisiana. There's like, no, we're not doing that. We're not coming. This was a state court subpoena issued through letter of rogatory in Texas, but they were outside of the jurisdiction. So we ended up having to take the deposition of one of the play people where the company existed, and then another person who worked remote. To our other point, we had to go to Mount Pleasant, Texas, to take their deposition because it was with we had to go to them.
Yeah. So some of the things when we've been, when I've been issued subpoenas for various things over the years, your emails, you're going to have to give all your emails, any and all email that references a discussion or a particular tract of land that's subject to the litigation. All that is out there. Everything you say in those emails is out there. It's going to go, and you can't hide it. You can't not submit it. We've been asked to submit reports, field reports. What's a field ownership report? Give me your run sheet. Give me any digital file that you received on this project. I need access to any of your correspondence back and forth with your landman while doing the work. Correspondence back and forth with your client, that you're working with, whether you're a company guy and you're talking with your landman in the field, negotiating an agreement, you have to have all that back and forth, and you're going to be required to submit all that. So that's kind of goes back to the importance of what you put in writing.
Yeah.
Could potentially be put in a transcript. It's going to be there in a file. And
to go back to that last part about ability or the reach of the subpoena, one thing to be very careful and make sure that you're reaching out to counsel if you're served a subpoena is that a lot of these landmen operate under an MSA with a confidentiality agreement in it that requires or makes an exception if you are responding to a court order. But that exception doesn't apply if the subpoena is not valid because you're outside the jurisdictional limits. So make sure you don't respond to the subpoena that you didn't have to respond to and then accidentally breach your MSA with your vendor.
Then you just cause all kinds of problems. So, I mean, that kind of goes back to don't avoid it. Whether you're the company side or the field side or an independent or whatever, when we get involved in this, you want to reach out to your client, inform them that, hey, I've been served a subpoena for this. You're a named party in this. That's often how it works out, right? It's two companies fighting it out, and you're a landman and you get brought into it, or you're a landman for company A, and you're duking it out with company B, and you're going to be involved. So be careful about what you're saying, how you're saying it. Have your email correspondence be clear, to the point, professional, and business-like.
Right.
Right. You don't want to put in writing, and I hate this son of a B, and I want to screw this sucker.
You may want to put it in writing.